I'm Joy Lim Nakrin here with attorney Josh Schiffer, and we are talking about the latest on the Trump investigation and that case. Of course, Josh, first of all, just want to get our viewers kind of caught up on some of the major headlines. Ray Smith III, an Atlanta or Georgia-based attorney, filed basically is trying to get a waiver for his arraignment, and also entered a plea of not guilty. That's one of the major new developments that's happened in the last 24 hours. What do you have to say about that? Is he going to be able to actually waive his arraignment?
Oh, I fully expect Judge McAfee is going to make it as smooth as possible. Assuming that Judge McAfee doesn't have another reason to really force him to come into court and stand for a media show. Waiving arraignment is a regular thing that happens here in Georgia in a huge number of criminal cases, especially felonies. Today really is the big, take a deep breath day. Yesterday, there was more information flow regarding former President Trump and his various cases than any other day previous. We had the Mark Meadows hearing. We had the hearing up in D.C. We have some scheduling orders. And, of course, now we're getting ready in this Georgia case for the upcoming arraignments next week. And what you're talking about with that particular defendant is in Georgia, arraignment is a stop on the process. It's like a train, and it's going down the tracks, and this is a really early stop. You've almost certainly been arrested, bonded out, or processed, been released, or still in jail, and the state has come up and indicted you by presenting your charges to a grand jury, and a true bill has been returned. But you, as the defendant, don't have a copy of that yet. And you can think about arraignment as being where you get a copy of your charges. Arraignments come back in time, or were developed back in time when most people didn't know how to read. That's a fact that 100 years ago, vastly larger numbers of our populace just didn't know how to read, and the founding fathers, along with other Western Renaissance-based countries, determined that an important stop on the justice process was the accused being formally told exactly what they're being charged with. And it needs to be really exact. An indictment, you are entitled to an indictment that's perfect in form as well as substance. And if there are big errors in the indictment, it can invalidate that indictment through a process called demurrer. And you're going to hear more about general and specific demurrers during the pendency of all these cases. That's a defendant through their lawyer basically telling the state your accusation or indictment has a flaw in it and therefore can't proceed. So the arraignment process, it goes back in time to where the judge, at your request, would literally read you the charges in open court so that everybody in the community would know exactly what you're charged with, the who, what, where, why, how of each and every charge. We don't necessarily need that now. And most criminal defense lawyers look at arraignment as being, a necessary but not super important mile marker. And for individuals that don't want to take the time to go down to court that day, certainly don't need it read out loud. We can accept paperwork. You fill out a form with the judge's permission, waive that arraignment, and basically the court doesn't need to deal with you that day. And that's what I expect to happen with some individuals, but not all.
So, let me punch this up again. Ray Smith. So he filed a waiver. He filed the paperwork for a waiver, but it still needs to be approved by the judge, correct?
Yes, the judge is going to have to weigh in on it, and it's up to the judge. It's one of these judges' discretion. Some judges really don't like it that much and can restrict your ability to do it. If the judge wants to force you to appear for arraignment, they have that power. But generally, just for efficiency's sake, judges don't want to clog up their courtrooms with unnecessary warm bodies on what is generally a plea and arraignment day. That's a calendar day where everybody is coming to court pretty much for the first time to receive that copy of their charges. So if you've got a lawyer and don't need to go down there, skip it. You waive arraignment, make it more efficient.
And, we've been talking, we reported this yesterday, that the arraignment date has been set, September 6th, for Trump and his 18 co-defendants. Maybe we see some other waivers. Maybe we see some other people trying not to appear at their own arraignments. But something else that we're going to be on the lookout for as well. If you had to guess, we were just talking a little bit about this off camera, Josh. First of all, do you think that a judge would actually, if Trump's team for himself granted a waiver so that he does not have to attend the arraignment, do you think that a judge would actually grant that, number one? And number two, do you think that the team would even do that? Or do you think they want the publicity?
That's a great question, because the answers really come down to strategy and preference. And there's a couple of stakeholder positions to look at. The Judge McAfee, knows that this case has more scrutiny applied than any other case he's ever handled, likely will ever handle again. So he's probably going to take a very conservative route when it comes to the process. That's to make the integrity of the case as bulletproof as possible. And if he feels that there's some benefit to an in-person explicit arraignment for all rights, he may call them in for that. We don't know whether this William Ray waiver is going to get approved. And right now, the schedule is that the arraignments are going to start at, I think, 9 or 9:30 a.m. on the 6th, and then every 15 minutes another arraignment is scheduled.
That's right.
That's a really busy schedule in a big facility that is going to have to handle the increased security and scrutiny of all the press, as well as the security for people like the president.
As you're mentioning it, I've actually punched it up on the screen so our viewers can see. 9:30 a.m., September 6th, that is when the arraignment is scheduled for Donald Trump. 9:45, Rudy Giuliani. 10 a.m., John Eastman, and on and on and on. And if you see 10:30 a.m., that is when the arraignment is scheduled for Mark Meadows. But very interesting, because we have seen the hearing for Mark Meadows take place this week. He's trying to get his case moved to federal court. He is also trying to get his case severed from. I guess it's really part of the same motion to get it severed from Trump and the others.
It's all part of one and the same, even though there are different case numbers. The federal action stands solely independent, and Judge Jones is going to make that ruling, but it doesn't forgive or excuse Mark Meadows from participating fully and completely with the existing Fulton County process. He's still going to keep going down the Fulton County road until Judge Jones makes his ruling regarding removal, potentially severance. There can also be severance motions filed in the state court process, and we're still waiting on judges to come back with some initial rulings on some of the requests in this and other cases. The important thing to remember is that the arraignment process isn't terribly long. It's an acknowledgement more than anything else. That begs the question as to whether there's a value to having these individuals all show up to protect the integrity of the case, or whether this is some sort of PR manipulation. And that could be from both sides. Some people could accuse Fani Willis of trying to excoriate and expose all these individuals by making them trudge back and forth to court in full view of cameras and all the scrutiny. At the other hand, though, President Trump or some of the defendants certainly have not shied away from media coverage. And this is a perfect example to illustrate exactly how challenging facing this case is on his operations, not only as a private citizen, but as an active candidate for President of the United States. These are not, in, out, and done necessarily. It's a whole production for someone like the former president to appear in a courthouse, even for such a short procedure.
Absolutely. I want to also point out that there is a bond hearing this week for one of the defendants, Harrison Floyd. And I also just want to point to the story on our website about that, because we have this all organized for our viewers, because I know there's so much to keep track of. I just like to keep reminding people, just go on our website, atlantanewsfirst.com, and you can kind of follow all the storylines. But Harrison Floyd is the only jailed defendant in this case, and he was apparently deemed a flight risk, and so I guess that's the reasoning for that. You have some comments about that.
Yeah, and this is really interesting, and I'm going to fully put on some sort of the criminal defense hat for this.
And let me just explain that he was a leader of Black Voices for Trump.
Yeah, his role is very different and set apart from a lot of the other individuals charged. As far as I know, he never had contact or direct instructions from any of the people at the top of this alleged RICO conspiracy. He was much more a frontline operator associated with Blacks for Trump that was then, alleged to have harassed and intimidated and really leaned on these Fulton County poll workers from the State Farm Arena, Miss Ruby and that crew. And it's interesting for a number of reasons. First of all, this is the only individual involved that has any other kind of substantive criminal record that we know of. That being, he was recently arrested and released under federal pretrial supervision for an incident with an FBI agent up in the Mid-Atlantic. I want to say it's Maryland. So he is actively out on some sort of pretrial federal monitoring and release. If you are arrested while on pretrial management and release, generally the remedy is to keep you in jail until you've appeared before that authority for disposition if there's going to be a violation of your pretrial agreement or something like that. But this is a little bit of an interesting case because he was arrested here in Georgia. He turned himself in. He turned himself in before the former president and many other individuals, all of whom, except for him, had a lawyer interact with DA Fonnie Willis's office prior to their turn-in and arrange a bond. Harrison Floyd did not arrange that bond, did not have a lawyer reach out to the DA's office, so therefore he really, in the words of Pat Labatt, Fulton County Sheriff, was treated just like anybody else. He was incarcerated, he was processed, and he was sent to first appearance the next day in front of Superior Court Judge Emily Richardson, who, using the powers vested in her, declined to grant him a bond, noting specifically that he had other issues elsewhere, as well as the fact that due to the case having been indicted, that there's not just a warrant but an indictment, the proper judge to determine bond would be Judge McAfee because the indictment has been assigned to Judge McAfee. Judge Richardson also declined to appoint a public defender at first appearance due to the fact that Mr. Floyd did not qualify financially for a public defender despite the outrageous cost retaining a lawyer would bring in this case.
Josh, I just wanted to interrupt you for a moment because I see, we have a lot of viewers writing on our YouTube channel right now, and someone is making a comment that you made before we actually got on the stream. 666 Happy Girl writes, he is the only black man.
Exactly.
And the only one out of 19 that has been jailed. And the leader is no place to be found to help him. Seems odd to me.
It's an absolutely accurate criticism of this process. Harrison Floyd is one of only 2 African Americans involved in this case, and he is the only one that is still incarcerated. I know that he has special circumstances as illustrated by the court, but optically, it's hard to shake the fact that racial disparities do appear on the face when it comes to the prosecution of this case. It's not like the gentleman wasn't easy to find. He turned himself in, and there's a strong argument that he should have been granted a very easy to pay bond or a signature bond or something else in order that he wouldn't have to suffer the indignity of pretrial incarceration in Rice Street. He is sitting there right now in a facility where, according to the most recent reports, yet another death happened in the last 24 or 48 hours.
Right.
That's 7, 8, or 9 this year in this facility. I visit this facility professionally.
It's the 4th in just the last month or so, the 4th death. It happened over the weekend. And it's still being investigated, and we're not sure the circumstances, but
needless to say,
Fulton County Jail
the conditions in Rice Street are indefensible. You will not find anyone, even the acting sheriff, who will tell you that it's being run efficiently and well and is a safe place. The regular threats and violence that anyone incarcerated in Fulton County, Rice Street are going to experience are just shocking, and I believe that Mr. Harrison Floyd probably is sitting with a bunch of people in general population is going to come out with some eye-opening stories of his treatment. The good news is that he has another court date coming up with Judge McAfee, and Judge McAfee very recently signed an order that's going to appoint Mr. Floyd a public defender. That public defender may need to be compensated at the end by Mr. Floyd because he does not qualify for public defense. But the important part is that Mr. Floyd will have a legal advocate speaking for his own best interest during this initial bonding process. I expect Judge McAfee will act quickly in setting a bond and putting Mr. Floyd back outside of incarceration and with instructions to handle his issue up in Maryland as well. But tying this case up with someone incarcerated is a complication I don't think anybody wants, and it just looks awful for him to be the sole African-American male.
And I want to also just get to another headline on our website, AtlantaNewsFirst.com, which is that the judge has set a potential release date for the special grand jury report, and that's going to be next Friday, September 8th, and that's when this full grand jury report is expected to be released, a special grand jury report. Josh, is this potentially going to be like a roadmap to the prosecution's case?
It's going to be met with overwhelming silence as every member of the media and culture sits down and reads this report the moment it is released. Remember, Fani Willis used her inherent authority as a district attorney in the largest county in Georgia to conduct an investigation. Special grand juries are granted extraordinary privilege and abilities, along with the assistance of the district attorney's office, to compel witnesses and evidence to appear before them in order to investigate, with the result of that investigation being this report. This was the report that, when it was concluded, is the roadmap, or creates, like you said, the roadmap for DA Willis to bring charges. It's going to be filled with recommendations from the grand jury as assisted by the DA's office, as well as almost certainly a summary of what work was performed during the investigation. That's going to include not just the individuals who were named in the indictment that DA Willis chose to draft, but certainly the other unindicted and currently unidentified co-conspirators and other participants in this alleged scheme. Not only do we have 19 people facing charges, but there were 30 unindicted co-conspirators, people that worked alongside. We're going to learn all about what that work product is. That report became the roadmap for Fani Willis. She's decided how to pursue this case. Now we're watching it all come true.
And Josh, I just want to share it because folks are chiming in on our website. Someone writes, I feel like all our tax dollars this year will be spent on this crap.
Boom. Huge.
Yeah, I want to ask you about that.
Huge. So my regular practice is in and around this community, and resource allocation has been a chronic and persistent problem in criminal defense in urban areas since before I was born. We have people waiting months and years while incarcerated to get their day in court, let alone people that have been arrested, released. Some of these individuals wait 2, 3, 4, 5 or more years for their case, their citizen case, to reach the court for disposition. What Fani Willis has chosen to do by pursuing the Trump 19 in the way that she has is place their case above in priority over all those other cases. And that's a hard decision she had to make. I'm glad she won the election, not me. I wouldn't want to have to make that decision because she's chosen to prosecute crimes which are her mandate at the detriment to the process and civil rights of other individuals facing criminal justice in Fulton County. Should this case move forward on the schedule that Judge McAfee and others are discussing, I imagine that's going to require basically a shutdown of the Fulton County system, the criminal justice system, down at Pryor Street, down at Central Ave, the sheriff's office for security. Their budget is going to be eviscerated in a short period of time. The human labor hours involved in securing such a large process is monumental. We will have never seen anything like it. And that cost is going to be in the millions, if not tens of millions of dollars. that feeds into some of the criticism and questions about the removal process, with many people in the criminal justice community saying, hey, we understand these are state crimes. We understand the DA has the obligation to pursue crimes, especially these big complex ones that other jurisdictions may not have been pursuing using Georgia law. But if we can shift those costs away from the county, maybe we should consider that, and that's what removal would include. I personally feel the federal system has much more robust resources to support a prosecution of the size and scope DA Willis is bringing, and I feel it would be more workable to move all of this trial work over to a federal facility, which, while very busy, doesn't have near the volume that the Fulton County Courthouse does. Remember, Fulton County Courthouse, you're going there for everything from dog bites and code enforcement all the way through rape and murder. This is an incredibly busy jurisdiction that already can't keep up.
Yeah, absolutely, absolutely. All right, well, Attorney Josh Schiffer, thanks so much for joining us with your expertise and analysis. Again, just want to point our viewers to AtlantaNewsFirst.com. And if you click on that Trump investigation tab right at the top, then you get to this page, and it just lays out everything, you know, as you can see, the key figures, the timeline, the grand jurors, and then we keep adding to the stories as new stories come down. You can see they're in chronological order, so you can get all the latest, because again, this is a fourth criminal case against the former president. So this one is right here in Fulton County, Georgia. All right, we'll keep it right here. Atlanta News First, Atlanta News First Plus, and AtlantaNewsFirst.com for all the latest developments. Thanks for being with us.